Good evening, everyone. So it looks like I'm going to be reviewing the chapters that was read by myself. So what I'm going to do is I'm going to start by reading off the questions for the chapter review, and then that's about it. So I'm going to be talking about chapter 19, 20, and 21. Chapter 19, Notary Ethics and Avoiding Conflict of Interest. So question number one. What parts of the chapter stood out for me? I didn't really get a chance to do a lot of highlighting, so I'm going to be free balling this, but I do remember some important points on the chapters that I read. Now, every notary, of course, should be familiar with published notary ethics standards, okay? Knowing what you can and cannot do when you're performing notarial acts, okay? Let's see. The notary should abide by the ethical duty to become and to remain informed about notary law and best practices. Very important. Um, a lot of the notary rules don't change a whole lot, but we have had some new laws that rolled out as of 2022. So that is something that everybody needs to make sure that they are knowledgeable on so that you're not out here doing what we used to be able to do in the present. Let's see. Now, I will say, chapter 19, 20, 21, it is really like a repeat of the previous chapters. So it's really not a whole lot of difference in viewpoint going on here. Um, Words changed up a little bit. Like I said, it looks like things are being repeated over and over again to just make the book longer, in my opinion. And then, like I said, here with the repeating. The notary should abide by the ethical duty to follow notary law and best practices in the performance of each document notarization. Ethical notaries know notary law and they obey it. Ethical notaries also know notary best practices and they adhere to those best practices. Ethical notaries do not allow neighbors, friends, or employers to persuade the notaries to take shortcuts or to dissuade notaries from following notary law and best practices. Ethical notaries are diligent and prudent about legal requirements and best practices. Ethical notaries take their duty seriously and they expect others to take document notarization seriously as well. I will say this passage here is what I see every day. People take all type of shortcuts simply because I don't have to do that in my state, which is fine. But there's a reason why there is best practices. There's best practices in any type of profession that you will do. And if you are one of those notaries who just don't want to do best practices, I really feel sorry for you because it doesn't make sense to take shortcuts, because you just never know. And, it's sad that people will literally look up, well, can I get in trouble for not doing this? Just just be a good notary, you know? That should not be hard. Now it says the notary should abide by the ethical duty to act with reasonable care and prudence in the performance of each document notarization. Exactly. Making sure that we are IDing these people who want us to perform our notarial duties for them. Making sure that we're journaling, making sure that entry reflects everything that you did during that transaction. You don't want to leave any shortcuts. You don't want to leave any documents, not listed in that journal entry. Oh, they had 4 or 5 of the same document. Then put the one document name and put that it was notarized 5 times if that's allowed in your state. Easy. You don't have to say this, put the same document over and over again. But then again, it does, like I said, depend on your laws in your state. And of course, it depends on the type of journal you're using, of course. The notary should abide by the ethical duty to act with impartiality and honesty in the performance of each document notarization. That is a no-brainer. We are impartial witnesses. That is what a notary public is. The notary should abide by the ethical duty to refrain from participating in an endorsement, promotion, testimonial, or a campaign of any kind. These can get tempting. Um, the thing I love about this book is that he has case studies in here, or what are they called? I mean, I enjoy reading those better than anything else. Okay, notes. What is it? What is it called? Not the notes. It's like basically case studies that he's been a witness to. But it says notaries bear the ethical responsibility to avoid taking part in endorsements, promotions, testimonials, or campaigns of any kind, with the exception of a genuine charitable cause that is not commercial or political in any way. This duty requires the notary to decline the performance of a document notarization, including the notary title, certificate, and seal impression, which the notary knows will be used in an endorsement, promotion, or testimonial or campaign. If the notary were to suspect possible intended misuse of the notarization, notary title, notary certificate, or notary seal impression, the notary should either decline to notarize or inquire directly of the document signer to determine the signer's intentions. If the signer's intention would violate this ethical standard, the notary should refuse to notarize. As always, the notary should prepare a detailed journal entry for the notarization, including the inquiry about intended use of the notarization. Okay. And then let me see. Were there parts of the chapter you thought were incredibly unique, out of place, thought provoking, or disturbing? The promotion one was definitely thought provoking to me because I had been a part of it was a charitable cause though, when I looked more into it. And it was on a radio station and they did do I think 3 commercials for me. But that was last year. They asked me did I want to do it again this year and I declined. But you gotta be careful with that. I know, it's always tempting to get your name out there so that you can be the person in that local area where you reside. You wanna be the preferred notary, but be cautious and don't allow them to use your public official rank to, mess it up for you. Like you don't want to mess up your commission. Now, the notary should abide by the ethical duty to assess the document signer's identity, mental competence, and willingness. It says times have changed dramatically for notaries in the last decade or two. Concerns about identity theft and document fraud have increased sharply. In response, there has been a sustained movement to enlist notaries more directly and more deeply in the fight against identity theft and document fraud by asking notaries to more carefully assess the document signer's identity, mental competence, and willingness for each instrument notarization. These 3 assessments are now critical to the integrity and security of document notarizations. Excuse me. Consequently, notaries bear the ethical duty to perform these assessments diligently, capably, and thoroughly, and to note the conduct of these assessments in the respectful journal entries. So, those passages that I read to you, those were definitely thought provoking to me. Now, how do you avoid an actual or apparent conflict of interest in the performance of each document notarization? You read the sections. I know they say, oh, you're not supposed to care about what's in the document. Okay, but your notary certificate, you should care about what's in that body of the certificate wording because you want to make sure that whatever it's asking you to do, that you're doing it. And if it's not asking you to do something, don't do it. So, yeah, you have to read that. This standard is stated to emphasize the basic reason for the group of several specific disqualifying settings discussed in the next sections that follow. An alleged conflict of interest is akin to an objection or unmoral grounds, impugning the integrity of the conflicted notary. It would be dishonest for a notary to serve knowing that there was an actual or even an apparent conflict of interest. So, hold on just a second. Excuse me. My cat is trying to get out the room. Okay, I'm back. Sorry about that. Okay, so it says the notary should abide by the ethical duty to refrain from notarizing the signature of the notary or notarizing a document in which the notary is named as a party in interest. I get asked these questions a lot. Where I am in Florida, we can both serve as a witness and a notary on the same transaction. The issue is, though, that you want to make sure that the certificate that you're notarizing does not imply that you're notarizing the signature of the witness as well. Because if so, you can't notarize it. Why? Because we cannot notarize our own signature. Okay. So this is something I already knew, but I wanted to say it out loud to you guys. And then, of course, the notary should abide by the ethical duty to refrain from notarizing for any known member of the notary's family in any degree of relationship by blood, marriage, or adoption. If at all possible, I know that we can notarize for some family. They just can't be mother, father, sister, brother, husband. But you can notarize for a cousin or something like that. Just my thing is, I'm not notarizing for family. Period. I don't care if I can notarize for my cousin. I'm not notarizing for no family members. So that's how you take care of that. You don't even have to figure it out. You just say, I'm not notarizing for none of y'all. Um, the notary should abide by the ethical duty to avoid profit or gain from a document notarization, other than the fee assessed for the notarization. When you read these books, you really, I know for me, it surprises me the things that they have to tell you because some things are just common sense. It really is, but common sense is not common. So, but it's sad that they have to list these things in these books to remind people to act ethically. You should not be notarizing a document that you know you're going to benefit from, other than the fact that you're just getting paid to do the notarization. And then it says the notary should abide by the ethical duty to refuse any gift or gratuity in connection with past, present, or future service as a notary. This answers this question here. Did you end up doing extra research on anything presented in the book? If so, what did you find? Yes, I ended up doing more research on that because I had a notary ask me some time ago, um, did you know that we can't accept tips, or do you accept tips? In the past, I have gotten a couple of tips from customers. I will no longer do that because I have found new information that I was unaware of. So, because we are public officials, it can be seen as bribery for us to accept tips or gratuity. Now, if you're not performing a duty as a public official, then yeah, you can get a tip. But if you're performing your duty as a public official, it is against the law for you to accept tips or gratuity for your notarizations. So yeah, I did my research on that. Won't be accepting any more tips. um, The notary should abide by the ethical duty to protect the integrity and corroborate the validity of each document notarization by preparing a notary journal entry for the notarization. Another no-brainer, but you know, some people are not going to do it. If their state doesn't require a journal, and they're like, I am not keeping a journal. I don't want to keep track of all that information. Really not good, but people do what they want to do. Not a best practice. I'm all for notary best practices. So, hence the name of the book. The notary should abide by the ethical duty to protect the confidentiality and privacy of information about the document signer and the notarized document. Again, a common sense statement. When we record private information for each one of the parties that we notarize for, we have to protect their privacy by keeping our notary journals in a safe place where only we can access it. That is common sense. That's a no brainer. Everybody who has a notary journal should be doing that. Now, the notary should abide by the ethical duty to provide sufficient personal assets, bond coverage, and or liability insurance to adequately protect against notary mistakes and wrongdoing. Yes, even if you're not a notary, every business owner should have some type of liability insurance to protect yourself and to protect those who you work for, okay, which is our customers, the public. A lot of states require you to have a bond. So we all know the bond protects the public. You should have additional insurance for yourself because that bond does not protect you, the notary. It doesn't. Okay. So you have to have insurance to protect yourself and you have to make sure you're protecting your public. Even if you're in a state that doesn't require a bond, you should be able to protect your customers. Okay. Because mistakes will happen. We're human. But you don't want your mistake to cause somebody else harm. Okay. Whether it be um, financial, mental, and then what about the other parties? Most times our wrongdoings will affect somebody financially, obviously, because um, we handle a lot of security documents, to secure funds or transfer of funds or um, to obtain property or relinquish property to someone else for sale. So you got to be careful. You got to protect yourself and your public. All right. So we're going on to chapter 20, the savvy notary and avoiding liability. Now, chapter 20 and okay, no, chapter 21 is that's it. Chapter 19 and chapter 20 are the same thing. But chapter 19 is notary ethics and avoiding conflicts of interest. And then the savvy notary and avoiding liability. Chapter 20 was literally a repeat of it. But I will um, point out a few things in here. All right, so hold on just a second. The notary should recognize conditions which may increase the risk of making mistakes in the performance of a document notarization. Now, this was the part of this chapter that I thought was incredibly unique and thought provoking. Okay. Every document notarization should be conducted with care and prudence, yet, not all notarial settings are alike. Okay. Some should trigger concerns in notaries about opportunities for possible mistakes and other wrongdoing, and notaries should respond accordingly with heightened caution and diligence. Now, unless you have a brick and mortar location, most of us meet our customers in their homes or in other public places, but um, it's important that we pay attention to our surroundings because if anything is going on around you that could cause you to make a mistake, if you're being rushed or it's loud and you can't, you're trying to, get through the notarization so you can get out of that situation, it's best for you to just not do it. If you cannot be put in a better environment to perform your duty, you should not be performing that duty because there is the chance that you could make a mistake and you don't want to make a mistake. Okay. Now, let's see. Anything else that, um, anything I end up doing research on? What surprised me most about the chapter I read? Do I have a new perspective as a result of reading the chapter? Did I learn anything I didn't know before? Okay. Let me see. No, like I said, it's really a repeat of last chapter. Excuse me. I ate dinner before I came on here, so I'm gonna be burping. I'm trying not to burp with my mouth open though. Stand a potential for criminal before I do a performance. Stand a potential for civil liability. Here. The notary should understand the potential for civil liability for wrongdoing in the performance of a document notarization. Notaries everywhere in the U.S. have full unlimited personal liability for any and all financial damages which they cause due to errors, omissions, or wrongdoing. Okay. Included are instances of negligent conduct and intentional misconduct by the notary. Notaries who have caused financial injury to document signers and or third parties who rely upon or are otherwise affected by faulty notarizations can be pursued by the injured parties for recovery of civil damages, meaning money. This field of law is called tort law, and the process may include the filing of a lawsuit against the notary. If a notary acts diligently and with reasonable care, but nevertheless makes an error or omission in a notarial act, the notary will not be liable even for financial injury resulting from the error or omission. Thus, reasonable care is a defense to notary negligence. In other words, notaries are not required to perform perfectly. Okay. On the other hand, if a notary acts negligently or commits intentional wrongdoing, the notary may face civil liability for damages. Notaries should keep in mind if they are accused of a mistake or wrongdoing in the civil arena. The burden of proof at a civil trial is the preponderance of the evidence. That is, the plaintiff, a document signer, or a party who relied upon a faulty notarization and was financially injured would have to present evidence sufficient by a mere preponderance to establish that the notary was negligent or acted with intentional misconduct. It is often said that this evidentiary standard means the plaintiff would need to win the battle of the evidence by a margin of just 51% to the notary's 49%. Thus, the notary should act with reasonable care at all times and should document the notary's diligence by maintaining a thorough notary journal. And having evidence to provide helps you because it will show that you took all the necessary steps even if something went wrong. Um, Notary journal will be admissible in evidence to demonstrate the notary's careful performance. Okay, and let me see. And lastly, for this chapter, the savvy notary will be prepared for potential risk and costs associated with the performance of document notarizations. Because the notary bears unlimited personal liability for financial damages caused due to mistakes and misconduct in performing document notarizations, the personal assets of the notary are at risk in claims against the notary. The notary should keep in mind that the cost of such claims can be significantly higher if lawsuits or administrative proceedings are initiated because the notary will need to hire legal counsel and pay the various expenses which can be triggered, such as fees for filing documents, depositions, court reporters, appeals, and so on. Okay. An individual should not become a notary public until she or he has sufficient financial resources to protect the public in the event of mistakes or misconduct. Okay. All right. Last chapter, chapter 21. I think I'm doing good. When notary statutes and regulations are silent. That's talking about some of these states' vague rules and regulations that they have set for notaries. Now, the notary should understand that many matters relating to document notarizations remain unaddressed by notary statutes or regulations. Excuse me. No notary statute nor regulation can cover every aspect of a subject as complex and important as document notarizations. It is impossible. Statutes are always incomplete and ambiguous. There are numerous reasons for the omissions and uncertainty. The English language is inherently difficult for defining terms and describing procedures. Legislators are unfamiliar with some of the subjects which they regulate by statutes they adopt and amend. Few legislators have been notaries, and very few seem to appreciate the significance of sound notarization practice in heightening document security and fighting against identity theft and document fraud. The numerous steps involved in document notarizations can be complex and difficult to explain, especially when it comes to describing exactly how to carry out sound and secure notarizations. Notary statutes have tended to remain brief and have not typically been revised or expanded to provide adequate treatment. Okay. The notary should understand how to deal with matters relating to document notarizations that remain unsettled by notary statutes or regulations. So, notary should first look to the other important source of law, which is called the common law. The common law is the body of law comprised of the published decisions of courts. If courts in the jurisdiction in question, or even in other states or territories, have decided cases on an issue, those common law opinions will provide law on the topic. But of course, notaries are not expected to be lawyers and to conduct legal research to discover court decisions. If there are relevant court decisions, they will undoubtedly be known by governmental notary oversight agencies, notary membership and education organizations, and by notary educators and experts. The practices derived from those common law decisions will be published or disseminated in official notary handbooks, notary education courses and conferences, and notary publications and online sites. So that means that you have access. So it's just about you learning how to search. It says that a notary should, in the absence of statutory or regulatory treatment, understand that a document notarization will be upheld if the notary substantially complies with its legal requirements. Okay. Absence of statutory or regulatory treatment, prepare a thorough notarial certificate for each document notarization. Mm. Here's another one that I had got just today. It was a question. In the absence of statutory or regulatory treatment, a notary should not attempt to alter or correct the notarial certificate after, after the notarial ceremony has been completed. So, for example, if you notarize a document and you signed it and you forgot to seal it, you can't just go back and say, okay, it's sealed. No, you have to complete the notarization all over again because that will be altering the certificate, and you can't do that. Let's see. Hmm. Okay, protect the notary seal. We already know that. Understand how to correct an illegible or partial seal impression. Understand the name and signature requirements for signers for document notarizations. Understand the duty to identify the document signer. Identify document signers by viewing one or more reliable signer IDs. So this all really touches on everything that we do anyway, every day. When we perform our notarial duties, we're IDing them. We're making sure the certificate is filled out correctly. We're making sure that we sign and seal the documents. Let's see. Checking for willingness and awareness. Hmm. Here we go. Notary statutes and regulations do not provide rules for notarizations for minors. Those laws do not prohibit notarizing for minors, nor do laws set age limits below which signers may not obtain notarizations. Thus, notaries should use their judgment and discretion in deciding whether to notarize for a particular minor, taking into account the minor's age and other circumstances. I did do a little bit more research on that. Let's see. We already talked about this. Do not notarize for any known family member. So you see what I'm saying about some of this stuff is just like a repeat of the previous chapters. The notary should, in the absence of statutory or regulatory treatment, not serve as a lay witness and notary for the same document. Yeah, so if at all possible, let them provide a witness. Okay. I think unless absolutely like the last resort, I will be a witness and notary on the same document as long as I'm not notarizing my own signature. I really prefer for the signer to provide a witness. I also am able to provide witnesses at an additional charge. Mm, the notary should not serve in the dual roles as drafter, preparer, and or reviewer of a client's document and as the notary on the same document notarization. Hope you guys already know that, but if you didn't, now you know. Yeah, let's see. Requesting thumbprints. Not a requirement, but highly recommended. And some places you can't do it, so it's all about following your notary law. So there's that. And most importantly, a notary should not redact information from a journal entry disclosed to do a request for access except for a signer's thumbprint. And of course, request for access, somebody who has a written request, they can request a journal entry. You just can't, make sure you cover up everybody else's entry. Um, definitely. And most importantly, do not be notarizing documents and your commission is expired. Yeah, you don't want to do that. It's against the rules. Definitely. And let's see. Anything else? I think that may be it, guys. I'm gonna look on some more of these pages to see if there's anything else I wanted to. Yeah, that's it. The notary should understand appropriate procedures to be utilized if the notary desires to charge fees for notarial services. Know what you can charge and what you can't. I hear people what do you charge for this? Look at your state guidelines. If your state charges, the National Notary Association has a list of fees that each state charges if your state charges a fee at all. So don't forget to look at that. And now we're done. Chapter 21 is complete. So the reason I went ahead and did this solo tonight is because I do have my notary course starting and I don't want to still be reading this book while I'm teaching my course. So I want to get through this and get it done. So we're going to be doing chapter for the next meeting, chapter 22, 23, and 24. Okay, 22, 23, and 24. So I'll see you guys next time. Same time, same place. Bye.